Welcome once again to our ongoing YouTube video series on technology law. My name is Christopher Neufeld of Neufeld Legal, and in this particular YouTube video we will be attempting to answer the question, why is it that your technology firm, your internet business company, requires a tech specific contract, especially when it is dealing with non-technology driven companies. And when I mean non-technology driven companies, I'm talking about companies whose primary focus is not necessarily technology, and individuals whose primary focus is not technology driven. They're not driven by the internet, although they utilize it and they have to interact with it. They are not driven by technology. So why is that the case? The case is because they utilize contracts and they have a mindset which is not driven by a tech person. And this is extremely important because their business arrangements with their contractors, their engineers, their service people, their consultants, their tax people, their lawyers, is not driven by tech. It is driven by other principles which are largely still antiquated and put back in the 20th century. As such, they work fine for the purposes that they were intended to, so long as they are not engaging a tech company. And why do I say that? I say that because tech companies bring to the table a lot more components that cannot be so easily classified in a standardized contract that they might be dealing with non-tech people. There is a lot of work that goes into the programming, into the layout, into the structuring, a lot of intellectual property, a lot of conceptualization that is replicated and that is specific to your own business. And this specificity needs to be retained by your business. It needs to be controlled by your business. And unfortunately, most of the contracts that you deal with, you might not realize it because the contracts by themselves are structured in such a way that they appear to be comprehensive. They appear to address all the points, but they fail to recognize the unique specificity of technology. And in so doing, they fail to address those concepts and those principles that are unique to tech businesses and for which your business needs to protect itself. And it cannot allow itself to give away aspects that it should not be given away, and that these companies are not necessarily looking to take away, but because for the most part their lawyers fail to comprehend and grasp the specificity of the arrangement and what it can entail and what it will entail. They simply rely upon templates and previous contractual arrangements that have gone well for 10, 20, 30 years for these lawyers. So they may be very experienced lawyers, but the fact that they fail to comprehend the technology aspect is crucial, and you cannot allow it. As such, you really need to be garnering a lawyer who has experience pertaining to technology and how that is brought to the fore within the contract, how it can be addressed, so as not to turn off the other side, but just to clarify why these aspects need to be modified and redrafted such that it properly protects technological concepts that you are going to be introducing, but you are also going to be retaining. And this is absolutely essential. I've seen it far too much with the contracts from major Fortune 500 companies that are presented to tech companies. and their contracts are simply inadequate for a tech company. It doesn't matter if it's a airline manufacturing company, an automotive company, a pharmaceutical company, a tobacco company, a major retailer, a major service provider. Many of their contracts appear sufficient. They appear very sophisticated. And yet, even for all the sophistication, the fact that nobody is a technology lawyer means that they do not grasp what needs to be put in there. And they do not see stuff. They put in stuff which is antithetical to a technology company. And it is only through a technology lawyer that they will be able to identify what those major issues are and address them, correct them, present them in such a way that it doesn't offend people, but at the same time protects the technology company, its innovations, its concepts, its developments, and allows it to move forward and to better serve the customer. That's the other thing. A better contract not only better serves the technology company, but better serves the customer that's acquiring the technology from them in their limited capacity. They're not acquiring the company outright, they're just acquiring a service. And it has to be properly presented in the contract and properly drafted in the contract. And that is what we see, and that is why it is strongly, strongly recommended that you engage a knowledgeable, experienced technology lawyer when dealing with these contracts with major companies, with smaller companies. Irrespective of the size, you need to protect your business and your technology. We hope you have found this video informative. Like it, subscribe to our YouTube channel, provide us with your comments. And as always, if you have issues relating to your technology and business, especially issues like we discussed in this particular video, of getting into contracts of major significance with a large, medium, and small companies, where the contracts fail to address the technology scope. Or you may think they do, but they really don't. But you want to be assured. Then contact us.